You don't want to leave this boot camp, this seminar, and then run into a situation where all of a sudden you get a brief from the other side that nobody mentioned at this seminar.
So if you have got a loan that was a performing loan, say in 2005 when it was originated, and you see a document that's produced on the other side in response to whatever objections you may be raising and whatever action you're taking, that says that loan, when it was still performing, was transferred into that trust in 2008, there is absolutely no way that could happen given the terms of the pooling and servicing agreement that were designed to meet these remit tax rules.
You cannot properly service the kinds of pools we're looking at today and make money on 25 basis points. You can't do modifications.
I really think the key thing here is to follow the note. If you look at the deal documents in these deals, they still transfer the mortgage or the deed of trust along with the note up the line. What they normally do is they'll assign the mortgage or they'll assign the deed of trust if your deed of trust stayed in blank. And to me, that's an incomplete real estate instrument. And then we've got the holder definition of the UCC. The thing you have to understand is the parties by their own deal documents have defined legally what they mean by the term holder. We're using their own documents against them, their rules that they set up themselves, their own perfection, transfer, and security rules. What I'm focusing on when I'm looking at these problems in the chain is when I see these documents that are presented to me, like I call an 8F document. I mean, there is no way that a mortgage note could be endorsed from the originator directly to the trust. It's really both. I mean, I see the standing real party and interest and perfection in bankruptcy is really the same type thing, basically. It's two different issues, certainly, but the problem with what they did not do is really the crux of the legal issue that affects both those theories, whether the real party and interest or have standing, or whether they are going to be a secured, perfected creditor in bankruptcy or not. There are many problems with the MERS database. The basic problem is this: the actual employees of MERS in Reston, Virginia have absolutely no control over what goes in that database. They do no due diligence to make sure the database is accurate or correct. The MERS database could never be authenticated as a business record to prove anything. If you use the allonge, like I mentioned before, you just can't have a one-page document that has just this information on it right here, just the endorsement. That would not be a sufficient allonge because it doesn't describe the name and address of the borrower, the amount of the original obligation, property address, etc.
One of the things that's very important for litigators to understand about transaction codes is that the system setup is done by folks in IT. The users have virtually no input, and IT people have no idea what to put, so they will rely heavily on the vendor's defaults. Want to ask somebody operating the system, what's a TRAN code 168? What's a 713? What does it do? And where you'll break them down is when you ask them, how do you know that's how the system applies it? Because they will never know.
I've said at the boot camps for years, the purpose of the boot camps is for you to know more about the other side's business model than their attorney knows. And that's the secret. We're going to go through the whole attorney network on the other side.